Hi folks, I'm Huntsville criminal defense attorney Andrew Segal of Segal and Segal. Today's topic is mental health defenses in the criminal justice system. Mental health issues can have a significant and profound effect on a criminal case. Depending on the nature and severity of these, they can be outcome determinative. When most people think of mental health defenses, they think of somebody who's pleading not guilty by reason of mental disease and defect. And we're going to start by talking about that, but there are other ways that mental health issues come to play in a criminal case. But let's start with that. If a lawyer is dealing with an individual whom they suspect has a significant mental health issue, one of the issues that the lawyer has to address, there's really two basic issues, but the first one is this person competent to stand trial? That is, do they have sufficient understanding to meaningfully assist their lawyer at trial, to participate and understand the legal system? If they can't do that, they really can't participate in the legal system, and of course there's a major problem. They may not be able to assume the role of a defendant, and so that's something that has to be addressed. The other most common issue is, what about at the time of the offense? If they were suffering from a mental illness, a mental disease or defect at the time of the offense, that may affect their ability to have the proper level of criminal intent to have, or to have formed the criminal intent to have committed a crime. They're not the same thing. For example, somebody may have had some sort of a mental health issue. There's an example of a woman who was under an epileptic attack. Another woman went to help her. The woman who was having an epileptic seizure stabbed the woman to death. At the time of the seizure, she had no idea where she was. She only knew she was being under attack. She did not have sufficient mental capacity to realize that somebody was trying to help her. She was so out of it that she had a mental health defense. And so that, in that case, the argument which was successful was that she was suffering from a mental disease or defect at the time that rendered her incapable of forming the necessary criminal intent to have committed the crime. Other issues are that somebody may have been fine at the time of the offense, but by the time trial rolls around, they may have suffered a mental health issue. I had a client who once had a very, very bad car wreck. At the time of trial, they basically had become their mental status was awful, and they really were not functional anymore. And you kind of try to talk to them, and you might as well have been talking to a doorknob. They didn't understand anymore, and it was a sad case, but they couldn't assume the role of a defendant because of that. So, to summarize, when they do this, to win on a mental health defense, and by the way, the burden is on the defense. It is the defense's burden to establish by clear and convincing evidence our evidence. So we have to establish that at the commission of the offense, as a result of some severe mental disease or defect, that the person was unable to appreciate the nature and quality or wrongfulness of their acts. And as I said, the burden is always by clear and convincing evidence. And so that's to show that at the time of the offense, like the epileptic woman's sample I gave you, that the person is not to be held legally accountable. There are dangers with these kind of defenses. The first is that juries traditionally do not like mental health defenses. They tend to view them as an excuse, and they are very seldom successful. Just telling you like it is. They are roundly rejected in most instances. Second, when juries do agree with a mental health defense, that does not necessarily mean that the person just wins and goes home. If it's a long-term mental health issue, a lot of times there's going to be, this is the end of the criminal case, may be followed up by a commitment, and the judge may, or the state may move to have the person committed to a mental health care facility, and they may spend as much time, or even a longer period of time, locked up, not in prison, but in a secure mental health care facility, basically in an insane asylum, until there is a ruling that that person is no longer a danger to the community, which might be for the rest of their lives. They, depending on the nature of their crime, they might have been out sooner than that. So winning may not be winning on those kind of cases. So they have to be delicately handled. In other words, a win might mean that the person still is deprived of their freedom for a very significant period of time. A criminal defense lawyer who suspects that their client is suffering from some sort of mental health issue typically will ask for the court to order what's called a forensic mental health evaluation. And these evaluations will be done to evaluate those two basic issues. The first thing they're going to evaluate is this person competent to stand trial? If they're not competent to stand trial, there's no point in going further. If the investigation determines that this person is not competent to stand trial, then the next thing that is going to be inquired of is, can this person be returned to competency? If they can't, the case is going to go away, it can't be prosecuted. If they can, then at some subsequent time, the case can be prosecuted. I had a case once with an individual whose IQ was, I believe it was a 50 or a 52. Your average Joe the plumber, the average guy on the street has an IQ of 100. A guy like Einstein was somewhere, I don't know, 160, genius. This guy was 50, so he was at the bottom of the barrel. In fact, I had it looked up, he was in the bottom 1% of the bottom 1%. So he was the dumbest 1% of the dumbest 1%. The state psychologist in that case said, gee, we've kept him for a while, and we've restored him to competency. Well, I looked at that and I thought, baloney. Went to the judge. I had the judge give us another psychologist who said the same thing, baloney. And I went to court and I said, Judge, you know, if they restored a guy with an IQ, I mean, this guy's a drooler, he doesn't even know to close his mouth. If they restored this guy to competency, a guy with an IQ of 50, bottom 1%, what do they do? Give him smart pills? I mean, give me a fistful of them, I'll take them right now. And the judge, fortunately for my side, was very agreeable. She says, you know, I'll tell you who's retarded on this thing. The state of Alabama is retarded if they can think that they can restore somebody from an IQ of 50 to competency. And she threw the case out. But in some cases, somebody may be, you know, there may be a substance issue involved, or they may be treatable, and there may be other things where somebody can be restored to competency. If the person can be restored to competency, that case can be back on the trial docket. And if it is, the case can be handled just like any other type of case. Now, if we get back on the trial docket and they've figured out that the fellow is now competent to stand trial, the next issue, of course, is, again, what was their mental state at the time? And they may or may not have a defense, depending on what the circumstances were. Did they at the time of the event know what was going on enough to have a defense or not? And it's a jury question. It's for the fact finder to do that. Just because a mental health professional says that, gee, they didn't understand the quality and nature of their acts doesn't mean that that's the end of the matter. A jury gets to decide that, and lawyers like myself or the prosecution get to cross-examine and argue either that the forensic evaluator was wrong, or there may be another forensic evaluator who says the completely different thing. So these are issues that are decided by juries. Now, the fact that I've been talking only about the little bit high drama of a not guilty or guilty by reason of mental disease or defect doesn't mean that that's the only issue that comes into play here. Most of the cases that we deal with are not that high drama. We get a lot of people who have some sort of a mental health issue. In fact, many criminal law cases have mental health issues that are not the high drama mental health issues where the issue is whether or not they're competent to stand trial or if they're suffering from a mental health issue at the time of the offense, but more common things. They might be mental health or behavioral health issues relating to maybe anger management, relating to substance or drug abuse, relating to, they might have some mental health issue like bipolar or something else that is not so significant as to warrant that kind of a defense, but that's something that needs to be looked to where the person has a behavioral health problem. And fortunately, nowadays the court systems have gotten much more advanced, and there's things that we can look at to really help people who are having those issues. And fortunately, the courts now are much more cognizant of these issues and willing to do things to help. We have a number of mental health courts. We have mental health court that is designed to help people with those kind of problems. We have veterans courts. We have a variety of counseling programs. All of that is to say is that if you have a person, or if you are that person, and you have a pending criminal case and there are some mental health issues that are involved, number one, don't be embarrassed about that. This stuff happens all the time, and nobody's going to look down on you. It's important that you get the help that you need. Feel free to talk to your lawyer, and you should talk to your lawyer, and understand that when you talk to your lawyer, anything that you say to that lawyer is confidential and privileged. They can't discuss it unless you give them permission to discuss it. Now, if it's a mental health issue, something that affects your case, you really probably want them to be able to discuss it with the prosecutor and the judge to be able to get you the help. Sometimes when people understand, it makes the difference. There's a famous story about guys riding the bus, and his kids are being obnoxious as all get out, and they're annoying all the other passengers, and he just kind of, finally somebody says to him, "Mister, why don't you control your kids? Obnoxious." The guy goes, I'm sorry, we're just coming from the hospital, their mother died. Oh, well, now all of a sudden you understand the guy. So sometimes people might engage in behavior, and we're going, that person's a jerk, and then you find out, oh, wait a second, and our perspective shifts. So when there's things going on in a person's life, unless the court system knows, they might just think this guy's just a jerk. But if we know what's going on, if we walk a mile in their shoes, we're better able to help a person. And we can't help unless we know. So don't be embarrassed about that stuff. And again, that's confidential between you and your attorney. Now, as far as to hire an attorney, then the court system will consider appointing you a lawyer depending on the nature of the case. If you're interested in hiring us, obviously that's how we make our living, so we're happy to talk to you. Different lawyers are different about the way that they get hired. In our case, we do not charge money for your initial consultation. Just come in and we'll talk to you. That's because of our particular philosophy is that you shouldn't have to pay an attorney to decide if you want to hire an attorney. I'm fond of quoting my dad, who, when I first started practicing and was deciding this issue, said, wait a second, if I had to pay $50 to go into Walmart to look around, you think I'd go in? And so, while other lawyers say, well, time is money, I got to pay for all of my time, I don't really agree to that. I think that, just like I said, I'm not paying $50 to go into a store to look around and decide if I want to buy. I think that you should be able to come talk to myself or my law partner, who's my wife, and decide whether or not you feel comfortable with what we're talking about, and if you think we can help you. And if you can, obviously, if we can reach an agreement, then you can hire us. At any rate, this video is meant to be an instructional video. Obviously, by your watching it doesn't make me your lawyer. But I do hope that the information has been helpful to you. If you want to give us a call, the number's below, and thank you for watching.